Hi, I'm Reed Bloodworth, the managing partner of Bloodworth Law with offices in Orlando and Winter Haven, Florida. Bloodworth Law serves as legal counsel for Florida businesses of all sizes across the state. Our employment law team can work with you remotely via video conference or in the office with the appropriate safety measures taken to protect you as we help you with your legal issues. Today, I'm going to talk about 5 ways to determine an independent contractor classification. Number 1, this seems obvious, but you'd be shocked at how often it doesn't happen. If you want to call somebody a contractor, have a contract with them in writing. There are a lot of, quote, independent contractors out there with no written contract. And that's about the most reckless thing you could do, is not have a contract with a contractor. A person that you retain to provide services to your business can be retained as an employee, or they can be retained as a contractor. But there are rules about what the effect of that is. Number 2, employees are protected from discrimination and harassment. Contractors are not. Number 3, employees have certain requirements with respect to minimum wage and overtime. Contractors do not. Number 4, employees have to be covered by workers' compensation policy. Contractors do not. Number 5, an employer's default desire is always going to be to classify somebody as an independent contractor. To prevent that from happening, there are various laws that say that if this person does not meet certain requirements, you may not classify them as an independent contractor. So, if I hire an IT consultant to come into my business, and my IT consultant has his own LLC, and he works for 17 different companies, there are lots of different clients, of which I'm just one. The IT guy is in business for himself, doing his own work, being an IT entrepreneur. He's properly classified as an independent contractor with respect to my firm. But there are situations that could be a lot more disputed. For example, a dog trainer is classified as an independent contractor, but has no written contract, works only for one business, has to wear the company uniform, works 12 hours a day, and is paid a daily rate of $180. This becomes a situation where the person should have been classified as an employee, and as a result, for those 12-hour work days, he's entitled to overtime compensation for the extra hours worked. As an employer, you want to make sure that those delineations are correct between an employee and a contractor. Because if you mess that up, you're liable for all the additional overtime, let alone if the employee is bitten by a dog. Consider holding regular consultations with an employment attorney to review your existing contractor policies and new rules put in place by your HR staff for your employees. This step can ensure you're in compliance with Florida employment law. Again, I'm Reed Bloodworth, managing partner of Bloodworth Law. Let's talk about how Bloodworth Law can help you, your employees, and your business.